Have you considered making your workers all contractors to save money? Be careful because the IRS may not agree with you, and that can cost you a lot. Hi, I'm Eric Bass with Venn Law Group. I want to talk with you about one of the most common and riskiest mistakes business owners make: classifying workers as independent contractors when they should be employees. We see business owners looking for ways to save time and money all the time. It's important to your business and your bottom line. Classifying someone as a contractor can seem like a smart way to do that. You don't have to pay the additional 7.5% of FICA taxes. You avoid unemployment insurance. They get no paid time off, training, or benefits. You agree on a rate, and that's all you pay. Seems like a win for the owner. However, there is a downside. Just because you call someone a contractor doesn't mean the IRS agrees. Even if the worker signs a contract saying they are a contractor, it might not hold up. The IRS and other government agencies will make their own decision. And if they say you got it wrong, you could owe back taxes, penalties, and interest. In fact, misclassifying workers can cost you 20 to 40% of unpaid payroll taxes, plus personal liability for what you should have withheld. Given these risks, you need to know how the IRS makes its decision. There is no one-size-fits-all test, but the IRS looks at three key categories. One is behavioral control. Do you control how and when the work is done? Two is financial control. Do you decide how the worker is paid, what expenses you reimburse, and whether they provide their own tools? And three is relationship type. Do you offer benefits? Is the relationship ongoing? Is the work a core part of your business? Here are some specific questions they ask about those categories. Do you provide training? Can the workers set their own schedule? Do they work for other companies too? Do they bring their own equipment? Can they hire their own assistants? Is the relationship long-term or project-based? Can they quit or be fired without penalty? Each yes or no nudges the worker closer to being classified as either an employee or a contractor. If the facts don't support contractor status, you may not have a choice. You'll need to classify them as an employee. But sometimes, with the right adjustments, like giving them more control or separating their work from your core business, you may be able to legally reclassify the role. The issue isn't just about saving on payroll. It's about protecting your business from audits, fines, and lawsuits. The bottom line is, if you control how the work is done, you're likely dealing with an employee. Don't risk getting it wrong. If you need help making the right call on how to classify your workers, contact Venn Law Group today, and we'll help make sure your team is classified correctly and legally.